On behalf of Advocate on Record Aspirants Academy, I welcome each one of you to our 8th lecture series. The topic for today is Avatar of Public Interest Litigation. On the last session, that is 7th lecture, we have dealt with how the PIL has originated. Today we are going to discuss how the PIL has taken different forms to help the marginalized people, people who hails from poverty, who is illiterate, how the public spirited person has filed public interest litigation to wipe their tears, to redress their grievances. Before going into the topic, it is our regular duty to recite the preamble before we start this session. So I request each one of you to recite the preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, preamble is considered to be a basic structure of the Constitution, and whatever the Constitution, the purpose of the Constitution is enshrined in the preamble. Therefore, as a prayer, we do it whenever the session begins. Now, with regard to PIL's consent, is there any separate provision to file public interest litigation? The answer is no. The writ petition, what we file under Article 32, if it involves the element of public interest, it becomes public interest litigation. So let us see first Article 32 Clause 1, what does it say? Article 32 is itself considered as a fundamental right, and according to Dr. B.R. Ambedkar, he has said in the Constituent Assembly that Article 32 is the very heart and the very soul of the Constitution, because whatever the fundamental rights that we have guaranteed to the citizens and the persons of this country, it becomes meaningless unless and until there is a remedy provided under Article 32. So therefore, it is considered as heart and soul of the Constitution. But Article 32 Clause 1 says, the right to move the Supreme Court, the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. This part means part 3. So whatever the fundamental rights that is guaranteed under part 3 of the Constitution of India, if there is any violation, any person can approach the Honorable Supreme Court. That is what it says. But the most important aspect is appropriate proceedings. How do you approach the Honorable Supreme Court for violation of your fundamental rights? By appropriate proceedings. The question arose. The answer is found in Article 32 Clause 2 itself by saying you file a writ of habeas corpus, mandamus, prohibition, certiorari, or writ of quo warranto. But how do you approach? You file a writ petition as prescribed in the Supreme Court rules, or can we even address a letter to the honorable judges? Therefore, that letter can be treated as a public interest litigation. There are several occasions where the Honorable Supreme Court has considered the letter as petitions because their purpose is they have interpreted the appropriate proceedings the Honorable Supreme Court has interpreted the term appropriate proceedings by saying it is not the form that we are concerned with. We are concerned with the purpose for the enforcement of fundamental rights. So therefore, the form is immaterial whether you file it by way of writ petition, accompanied by affidavit, attached by documents, or even a letter is sufficient. Therefore, the enforcement of the fundamental rights is paramount, not the form. That is what the Honorable Supreme Court has held. Now, with respect to the topic, avatar of public interest litigation, basically, if you understand the term avatar, that means it takes different forms, incarnation. So, what is that form that was taken by PIL? PIL is only one term, but how it has taken different forms. When the public interest litigation is filed for the prisoner's rights, it takes the different form. If the PIL is invoked for protection of women or against to protect women from sexual harassment at workplace, it takes a different form. A PIL takes a different form for bonded laborers, for neglected children. So it takes different form for environmental issues. So PIL is saying, but with reference to what context the PIL is invoked, it is interpreted by the Honorable Supreme Court in different ways. Ultimately, dear friends, the object of public interest litigation is that if any of the fundamental rights guaranteed under Part 3 of the Constitution, if it is violated, the bonded laborers, neglected children, women who is in down south or who is not having access to justice, how will they approach the Honorable Supreme Court? Through a public spirited person, NGO can speak for the voiceless people, therefore they can have easy access to justice. Therefore, doors of the justice is opened not only for the person who has means to engage a lawyer, but also for those who is illiterate, neglected, underprivileged. So for those people also, the Honorable Supreme Court has paved the way for them to redress their grievance before the Honorable Supreme Court. Now, let me move on to the 5 different avatars of PIL. The first avatar of PIL that I would like to touch upon is about prisoners' rights. How the PIL letter is treated as habeas corpus petition to protect the prisoners' rights. That is my first topic, first avatar of PIL's concern. Second avatar is with respect to gender equality. Gender equality, where I would be dealing with Vishaka versus state of Rajasthan, where transgender, they are identified as third gender. They should not be treated inhuman at all. So that is one form of avatar of PIL. Yet another form is environmental issues. How PIL is filed to protect the environment is concerned. So on these forms of avatars of PIL, so I would be dealing with relevant judgments, landmark judgments. Therefore, it will give more clarity to the subject matter. Now, first and foremost is, I would like to touch upon Sunil Batra case. Sunil Batra 2 versus Delhi administration. It is reported in 1980, volume 3 Supreme Court cases, page number 488. I repeat, Sunil Batra 2 versus Delhi administration, 1980, volume 3 Supreme Court cases, page number 488. I must tell you who are all the honorable judges who decided this case. Honorable Justice V.R. Krishnaiah, Honorable Justice R.S. Pathak, Honorable Justice O. Chinnappa Reddy. What is the case is all about? Sunil Batra was undergoing a death sentence in prison, TR jail. He wrote a letter addressing to the Supreme Court by saying his inmate name called Premchand, he is being tortured by the jail warder. Jail warder wanted money from the relatives who visited Premchand. But Premchand and the relatives did not pay. Therefore, he started having motive against Premchand and started harassing. At one point of time, he inserted a rod into the anus and it was bleeding. No proper treatment was given. So therefore, it was being witnessed by Sunil Batra and he addressed a letter to the Honorable Supreme Court. Honorable Supreme Court was shocked to know what is happening inside the prison. And then they appointed the advocate commissioner to visit the prison, understand what is the ground reality, and the advocate commissioner made a report stating that whatever the letter, veracity in the letter is true, and he is very badly treated, he was very badly treated. So, by which that letter was treated as a writ of habeas corpus. And then the Honorable Supreme Court has said the prisoners are also the persons. Once, say for example, who is there in the prison? When they commit certain offense, when the competent court punish them and they undergo a sentence inside the jail. Now the question is whether those prisoners have given their farewell to all the fundamental rights guaranteed under Part 3? The answer is no. That is what our honorable judges in this case, they have said, prisoners are also persons and not animals. Prison walls are made out of stones of law. This prison is also established in the Indian earth, and Indian earth is being ruled by the rule of law, that is constitutional law. So therefore, whenever the prisoners are traumatized, the constitution suffers the shock. So therefore, prisoners should be treated with dignity. So these are the words of our Honorable Justice V.R. Krishnaiyer. So I would like to quote some of the relevant paragraphs mentioned in the judgment. Therefore, it will give us more clarity. The present writ petition originated from a letter written to the Supreme Court judge by Sunil Batra, a prisoner in Tihar jail, Delhi, complaining that a jail warder had pierced a baton into the anus of another prisoner serving life term in the same jail as a means to extract money from the victims through his visiting relations. In response, the court initiated proceedings in the nature of habeas corpus and issued notices to the state and the concerned officials, appointed amicus curiae counsel and authorized them to visit the prison, meet the prisoner and see relevant documents and interview necessary witnesses so as to enable them to inform themselves about the surrounding circumstances. Consequently, it was found that the victim was placed in a punishment cell by the jail authorities. From the jail hospital register, it appeared that the victim had developed tear of anus, and as his bleeding could not be stopped in the jail hospital, he had to be removed to the Irvine Hospital, Delhi. The prisoner's later narration to the doctor in the hospital corroborated the case. So this is the facts of the case, dear friends. Now, what is the judgment? Let me read paragraph 5. Prisons are built with stones of law, and so it behoves the court to insist that in the eye of law, prisoners are persons and not animals, and punish the deviant guardians of the prison system where they go berserk and defile the dignity of the human inmate. Prison houses are part of Indian earth. And the Indian constitution cannot be held at bay by jail officials dressed in a little brief authority when part 3 is invoked by a convict. For when a prisoner is traumatized, the constitution suffers a shock, and when the court takes cognizance of such violence and violation, it does like the hound of heaven, but with unhurrying chase and unperturbed pace, deliberate speed, and majestic instancy, follow the official offender and frown down the outlaw adventure. So, this is what the Honorable Supreme Court has held in this case. Further, they issued different guidelines. Let me take you to the relevant paragraph. Ultimately, the Honorable Supreme Court has issued certain guidelines that prisoners should be treated with dignity and they should not be harassed. And if such position happens, if such condition prevails, the Honorable Supreme Court will issue writ and then rescue those prisoners from the jail. So this is a most important judgment where the letter is treated as a writ of habeas corpus based on which the order was pronounced. Now let me move on to the next interesting case, that is Bandhua Mukti Morcha versus Union of India. Bandhua Mukti Morcha versus Union of India and others. This case got reported in the year 1984, volume 3 Supreme Court cases, page number 161. I repeat, 1984, volume 3 Supreme Court cases, page 161. This case has come up before Honorable 3 judges bench, that is full bench, before Honorable Justice P.N. Bhagwati, Honorable Justice R.S. Pathak, and Honorable Justice Amarendra Nath Sen. What is this case is all about? I will just give a brief background and then I will take you to the relevant portions. Here, Bandhua Mukti Morcha is an NGO, non-governmental organization working for bonded laborers. They found that there are bonded laborers working in a stone quarry in Faridabad where they were not given proper treatment. They were living in a very, very poor condition, no proper shelter, no proper air because air was polluted and they were living just like an animal. So Bandhua Mukti Morcha, they wrote a letter, addressed a letter to the Honorable Supreme Court. The Honorable Supreme Court, after reading the letter, they appointed the commission, Advocate Commission. The commissioners went and inspected the premises and they made a report to the Honorable Supreme Court by saying, yes, whatever mentioned in the letter, that is genuine case. So therefore, through this letter, they treated as a writ petition and they passed several directions and ultimately those bonded laborers were released forthwith. So we have seen one avatar of PIL protecting the prisoner's right in Sunil Batra case. Yet another PIL avatar where it has protected the bonded laborers. They were living just like animal without any rights, without understanding the fundamental rights which are guaranteed to them. Ultimately, those bonded laborers cannot have access to the Supreme Court because they were illiterate and they cannot have means to engage the lawyer, but through NGO, non-governmental organization, they had access and ultimately got justice. Now I will take you to the relevant portions of the judgment. See, there are certain preliminary objections raised as to the maintainability of the petition. Reason is it's a letter written by Bandhua Mukti Morcha. So what is the preliminary objection that was objected before, that was submitted before the Honorable Supreme Court? The respondents, that is Union of India, raised a preliminary objection as to the maintainability of the petition itself. So what are the grounds that they have urged that this petition is not maintainable? Number one, Article 32 of the Constitution was not attracted to the instant case, as no fundamental right of the petitioner or of the workman referred in the petition were infringed. So no fundamental right at all, therefore there is no violation, therefore writ petition cannot be maintained. This is the objection by Union of India. Number two, second objection is, a letter addressed by a party to the court could be treated as a writ petition, and in the absence of any verified petition, the court could be moved to exercise its writ jurisdiction. How a letter can be treated as a petition if the averments were not verified by the deponent? So that is also one of the objections. The third objection is, in a proceeding under Article 32, the court was not empowered to appoint any commission or an investigating body to inquire into the allegations made and make a report to the court on the basis of the inquiry to enable the court to exercise its powers and jurisdictions under Article 32. So we have seen what are the facts, and now we have seen what are the preliminary objections by the Union of India. Now, how it is being dealt with by the honorable judges. Very important, dear friends, the interpretation of Article 32, this is by Honorable Justice P.N. Bhagwati, very beautifully written. The interpretation of Article 32 should be guided not by any verbal or formalistic canon of construction, but by the paramount object and purpose for which this article has been enacted, and its interpretation must receive light from the preamble, the fundamental rights and the directive principles. So how Article 32 is being interpreted here? Article 32, you should not see mere Article 32. Article 32 is a remedial measure for the fundamental rights guaranteed under Part 3. So therefore Article 32 should not be read in isolation. It has to be read along with the preamble. Preamble is the key to the Constitution. So we must always read with preamble, then fundamental rights, and then the directive principles of policy, and then read or interpret the Article 32. That is what the Honorable Supreme Court has said. There is no limitation in regard to the kind of proceeding envisaged in Article 32 Clause 1, except that proceeding must be appropriate, not in terms of any particular form, but appropriate with reference to the purpose of the proceeding, that is enforcement of fundamental rights. Here in Bandhua Mukti Morcha, a letter was addressed that is treated as a petition, writ petition. Now the objection is, in a writ petition, the Supreme Court rules prescribe certain procedures. Draft has to be facts of the case, and then grounds verified by affidavit, supported by the documents. But in this letter, nothing is there, just a letter alone, no affidavit, nothing. Therefore, that was the objection by the Union of India. But the Honorable Supreme Court has held, we are not concerned with the form, we are concerned for the enforcement of the fundamental rights. The purpose is enforcement of fundamental right. Therefore, if anybody's fundamental right is violated, we will see whether their fundamental right is violated or not. We will not see through which form they come. See, we as a lawyer, we come to the Honorable Supreme Court. We are not concerned with what commutation we come. We come by walk if our house is nearby. We come by metro, we come by car. That is immaterial. What is material is what is our role and how are we dealing with the case, how are we making our presentation before the court. That matters a lot. So similarly, the form is immaterial, the purpose is material. There is a quotation by saying, don't judge a person by his cloth and don't judge a book by its cover. Cover may be old, but the golden words are written inside. So that is what. So don't always see the form, but see the purpose. Whenever there is a violation of fundamental right, anyone, even a person, other than one whose fundamental right is violated can move the Supreme Court under Article 32 for enforcement of fundamental right, though ordinarily the court would not, in exercise of its jurisdiction, intervene at the instance of meddlesome interloper or busybody, and would ordinarily insist that only a person whose fundamental right is violated should be allowed to activize the court. See, generally, the general practice of the Honorable Supreme Court is whenever there is a person is aggrieved, an aggrieved person alone must approach the Honorable Supreme Court. That is what the doctrine of locus standi says. What is your locus to maintain this petition? How are you aggrieved? Which fundamental right is violated? How are you aggrieved? Establish your locus standi. But as far as the public interest litigation is concerned, doctrine of locus standi is diluted. Any public spirited person, when he has no personal interest, not having some personal vendetta, if it is really a genuine case, he can maintain PIL before the Honorable Supreme Court. So therefore, we are not concerned. The Honorable Supreme Court has held in this case, though Bandhua Mukti Morcha, their fundamental right is not violated, but it is a public spirited organization where it wanted to protect the fundamental rights of the bonded laborers who is unable to have access to the Supreme Court. Therefore, public spirited person, public spirited organization can maintain public interest litigation on behalf of poor, illiterate. Now, Honorable Justice A.N. Sen, whenever any person is wrongfully and illegally deprived of his liberty, it is open to anybody who is interested in person to move the court under Article 32 for his release. It may not very often be possible for the person who is deprived of his liberty to approach the court, and by virtue of such illegal and wrongful detention, he may not be free and in a position to move the court. The Supreme Court has amplest power under Article 32 Clause 2 to issue whatever direction, order or writ that may be appropriate in a given case for the purpose of enforcement of a fundamental right. It is not confined only to issuing the high prerogative writs which are hedged in by strict conditions differing from one writ to another. This is clear from the words in the nature of, or in clause 2, the court has discretion to evolve a procedure appropriate in the circumstances of a given case for the purpose of enabling it to exercise its powers to issue such direction, order or writ. There is no constitutional compulsion to follow the adversarial procedure only. The court can adopt such procedure as it thinks fit in exercise of new jurisdiction created for the enforcement of fundamental rights. Dear friends, fundamental rights which are guaranteed under 32 clause 1 and 32 clause 2, by which you file a writ of habeas corpus, mandamus and other writs, it is not only that, it has, the Honorable Supreme Court has powers to issue any directions in the nature of any other writs. So their power is unlimited. Therefore, you cannot confine the powers of the Honorable Supreme Court under only 5 writs. If we have understood that Supreme Court has the power only to issue 5 writs, that means we are mistaken. They can issue any directions. They can issue guidelines also. So public interest litigation is not in the nature of adversary litigation, but it is a challenge and an opportunity to the government and its officers to make basic human rights meaningful to the deprived and vulnerable sections of the community and to assure them social and economic justice. Dear friends, when we started the lecture, we started with a preamble. There, in justice, social justice, economic and political justice we read. See how 32 clause 1 or public interest litigation is interpreted in light of the preamble. And assure them social and economic justice, which is the signature tune of our constitution. When the court entertains public interest litigation, It does not do so in a cavilling spirit or in an inconfrontational mood, or with a view to tilting an executive authority or seeking to usurp it, but its attempt is only to ensure observance of social and economic rescue programs, legislative as well as executive, framed for the benefits of have-nots and the handicapped, and to protect them against violation of their basic human rights, which is also the constitutional obligation of the executive. The court does merely assist in realization of the constitutional obligations. The government and its officers must welcome public interest litigation. See, once we file public interest litigation, it does not mean that it is adversarial litigation against the state or the union government. So it should not be dealt like that. It is, the purpose is fundamental rights must be guaranteed. When there is a violation, with respect to the government where they have violated, so that they should have the remedy. So therefore, when the court is treating the letters as public interest litigation, the government should not feel bad about it. Otherwise, it should be treated as if it is an opportunity to rectify themselves. Therefore, whatever stated in the fundamental rights, it becomes meaningful exercise, and the fundamental rights can be realized by the citizens of this country. So, who can approach? Where one of the parties to a litigation belongs to a poor and deprived section of the community and does not possess adequate social and material resources, he is bound to be dealt at a disadvantage as against a strong and powerful opponent under the adversary system of justice. Because of his difficulty in getting competent legal representation, and more than anything else, his inability to produce relevant evidence before the court, the problems of the poor are qualitatively different from others, and they need different kinds of lawyering skill and a different kind of judicial approach. Therefore, when the poor come before the court, particularly for the enforcement of their fundamental rights, it is necessary to depart from the adversarial procedure and to evolve a new procedure which will make it possible for the poor and the weak to bring necessary material before the court for the purpose of securing enforcement of their fundamental rights. Now they have discussed why this public interest litigation, even the letter, are being treated as a writ petition. So that is what they say is, when a poor is there, illiterate is there, when they have no means to engage a lawyer, the Supreme Court cannot treat the rich and the poor at the same level. For the poor people, it should be approached with some sort of sympathy. Therefore, letter can be treated as a petition without following the proper procedure. Therefore, they get their fundamental rights, whatever is guaranteed. Now, who can maintain it? They say public spirited person. So they have said, where a member of the public acting bona fide moves the court for enforcement of the fundamental right on behalf of a person or class of persons who, on account of poverty or disability or socially or economically disadvantaged position, cannot approach the court for relief, such member of the public may move to the court even by just writing a letter. Such member of the public may move the court even by just writing a letter, because it would not be right or fair to expect a person acting pro bono publico to incur expenses out of his own pocket for going to a lawyer and preparing a regular writ petition, for being filed in court for the enforcement of fundamental right of the poor and deprived sections of the community, and in such a case, a letter addressed by him can legitimately be regarded as an appropriate proceedings. So in this case, the Honorable Supreme Court has held that under what circumstances public interest litigation can be maintained. Even a letter can be treated as a PIL. Under what circumstances? When the bonded laborers who are living in a very poor condition, and have no means to engage a lawyer, and they do not know what are the fundamental rights guaranteed to them, how do you expect them to have access to the justice? Therefore, any public spirited person who is very much aware about the legal rights, fundamental rights, and then they can approach the Supreme Court. Can we expect some public spirited person to spend their own money to engage a lawyer, to have all the expenses? That is not possible. So, therefore, the Honorable Supreme Court has held any public spirited person with bona fide is not expected to spend their own money out of their own pocket. So they can write a letter. We will see, as an Honorable Supreme Court, we will see, we will check the veracity. If it is genuine, we will take it as a writ petition and we will give a remedy to those who are with full of tears. This is what the Honorable Supreme Court has held in Bandhua Mukti Morcha. So we have seen two avatars of public interest litigation. One is protecting the prisoners' rights, another one is the bonded laborers. But in order to prevent the misuse of public interest litigations, the Honorable Supreme Court has come out with the guidelines. This is very, very important, dear friends. As a AOR aspirant, you must know what are the guidelines. They have given nearly 10 points. So, under those circumstances only, the letter will be treated as a public interest litigation. And they have prescribed nearly 5 points where it will not be treated as public interest litigation. And they have maintained, they have opened a public interest litigation cell, in short PIL cell. Any letter, if it is addressed, it will go to public interest litigation cell. The cell will scrutinize the letter and then they will place it before a judge, single judge, Honorable Single Judge of the Supreme Court, nominated by the Honorable Chief Justice of India. The single judge will scrutinize and then matter will be listed before the court. Therefore, it is not, nowadays it is not that you write a letter directly as Sunil Batra or Bandhua Mukti Morcha. Now you have got a PIL cell to scrutinize whether the letter would fall within the 10 conditions, 10 cases or 10 parameters. Then only it will be treated as a petition, otherwise the answer is no. So Supreme Court of India, it's a compilation of guidelines to be followed for entertaining letters, petitions received in this court as public interest litigation, based on full court decision dated 1st of December 1988 and subsequent modifications. No petition involving individual or personal matter shall be entertained as a public interest litigation matter, except as indicated hereinafter. So, if a person have a personal interest, you cannot convert that into a public interest litigation. So, what are the parameters? Let us see one by one. Letter petitions falling under the following categories alone will ordinarily be entertained as public interest litigation. Number 1, bonded labor matters. Just now we have seen Bandhua Mukti Morcha, where letter is treated as a petition to release the bonded laborers. Neglected children, who is very poor, who is neglected and nobody, they don't have means at all. So for neglected children, a letter can be treated as a petition. Number 3, non-payment of minimum wages to workers and exploitation of casual workers and complaints of violation of labor laws, except in individual cases. So even we can say in Bandhua Mukti Morcha also, they were not treated properly, no wages are given. So therefore, it can be treated as PIL. Number 4, petitions from jails complaining of harassment for premature release and seeking release after having completed 14 years in jail, death in jail, transfer, release on personal bond, speedy trial as a fundamental right. So we have seen this Sunil Batra case where one of the prisoners were treated badly. So prisoners, when they were dying, when there is a custodial death also, when prisoners are not treated properly, when they have crossed sentences 14 years and more, or speedy trial, if a pre-trial prisoners are there and they are in jail and waiting for their trial, so they can also write a letter to the Honorable Supreme Court. Fifth condition is petitions against police for refusing to register a case, harassment by police, and death in police custody. That can also be treated as PAL. Letter can be treated as PAL. Petitions against atrocities on women, in particular harassment of bride burning, rape, murder, kidnapping, etc. Even very recently in Kolkata case, murder and rape case, that case was taken suo motu by the Honorable Supreme Court, and this will fall under this also. Why they have taken it? Yes. Number 7, petitions complaining of harassment of torture of villagers by co-villagers or by police from persons belonging to a scheduled caste and scheduled tribes and economically backward classes. Number 8, petitions pertaining to environmental pollution, disturbance of ecological balance, drugs, food adulteration, maintenance of heritage and culture, antiques, forest and wildlife, and other matters of public importance. Ninth point is petitions from right victims. Number 10 is family pension. So these are the 10 categories under which a letter can be treated as a public interest litigation. So all letter petitions received in the PIL cell will first screened in the cell, and only such petitions as are covered by the above mentioned categories, whether such letters fall under these 10 parameters, will be placed before a judge to be nominated by Honorable Chief Justice of India for directions, after which the case will be listed before the bench concerned. And let me take you to the relevant portion also, yet another relevant portion. Cases falling under the following categories will not be entertained as public interest litigation, as these may be written to the petitioners or filed in the PIL cell as the case may be. So they have given 5 categories, where if a letter is addressed on those 5 categories, that will be written back to the person who wrote it. First, where it will not be treated as PIL, landlord-tenant matters. Landlord-tenant matters, if there are any issues between them, a letter cannot be addressed to the court by saying right to shelter is violated, therefore my fundamental right is violated. So landlord-tenant matters cannot be treated as a PIL. Number 2, service matters and those pertaining to pension and gratuity, that is not treated as PIL. Number 3, complaints against central or state government departments and local bodies, except those relating to number 1 to 10, what is prescribed, what I read earlier. If there are complaints against the police officers or the prison jail authorities, when it is falling under these 10 categories, it is admitted, otherwise no. Admission to medical and other educational institutions, that cannot be treated as a PIL. Number 5, fifth category is petitions for yearly hearing of cases pending in high courts and subordinate courts. When a matter is pending in high court or subordinate courts for many years, you cannot file a writ petition saying that it is pending for so much time. So therefore, dear friends, now the Honorable Supreme Court, these guidelines under which they will scrutinize whether if a letter addressed by a person who alleges that his fundamental right is violated, whether it would fall under these 10 categories. Only then it will be scrutinized properly by a PIL cell, and then it will be forwarded to an honorable single judge who was nominated by the Chief Justice of India. Only then it is listed before the honorable court. And what are the categories under which it cannot be considered as PIL, that is landlord, tenant, service matters, and any other complaints against the state and the union government, when it does not fall under 10 categories, those cannot be treated as PIL at all. So now we have seen three avatars of PIL. One is protecting the prisoner's right, another one is bonded laborers, and what are the guidelines given by the Honorable Supreme Court. Now let me move on to the yet another avatar of PIL, that is gender equality. So for this gender equality, I would like to refer to a very, very important judgment. Vishaka and others versus state of Rajasthan and others. Vishaka and others versus state of Rajasthan. It is reported in AOR 1997, Supreme Court, page number 3011. I repeat, AOR 1997, Supreme Court, page number 3011. This matter has come up before the Honorable 3 judges bench, full bench, Honorable Justice J.S. Verma, Chief Justice of India, Mrs. Sujata V. Manohar, Ladyship, and Honorable Justice B.N. Kirpal. So this case came up before the Honorable Supreme Court. What is the issue? Let us read that. This writ petition has been filed for the enforcement of the fundamental rights of working women under Article 14, 19, and 21 of the Constitution of India, in view of the prevailing climate in which the violation of these rights is not uncommon. With the increasing awareness and emphasis on gender justice, there is increase in the effort to guard against such violations, and the resentment towards incidents of sexual harassment is also increasing. The present petition has been brought as a class action by a certain social activist and NGO with the aim of focusing attention towards this societal aberration and assisting in finding suitable methods for realization of the true concept of gender equality and to prevent sexual harassment of working women in all workplaces through judicial process to fill the vacuum in existing legislation. See, when you are saying equality, men and women should be treated equally, and everybody has a right to carry on their profession, occupation, which is guaranteed under Article 19(1)(g). But when you do not provide a safe condition for working, for example, the classic example is Kolkata case, where doctor was raped, brutally raped and murdered. Despite Vishaka as well as the other statute is there, but still why it is not changed? The reason is the mindset of a person must change. There may be many laws, there may be many judgments, but who is supposed to follow? The judgments, the system is prevailing for the citizens of this country, for every Indians. So therefore, we must change our mindset. How to change our mindset? Three things we can do. We can always ask ourselves this question, because India is something, it is a union of people. If union of individuals is a group of states becomes part of India and they are India. So every Indian strive to do excellence in their field, whatever they field. First and foremost is the action flows from the words from thoughts. So when we monitor our thought process, because there are millions of thoughts that come across, but how to filter it? See, the client may tell us many things, but we filter it as an advocate and we scrutinize and we file only the relevant portions, relevant pleadings, or otherwise it is material pleadings that we make. Likewise, every thoughts will not take the action, will not take the form of action. So once bad thought comes in our mind, delete it. Only when it is good, speak. So whenever you ask yourself, is it a good thought? What you are going to speak, what you are going to speak, is it a good speech? What you are going to do, is it a good action? When we scrutinize ourselves under these three parameters, I think we can do something. It is generally said that have your heart, make your start, and don't hesitate to play your part. We can ask ourselves this question, can we change the system? But that doesn't mean that we do not play our part. As an individual, whatever the possible manner that we can do, we have to do it. So whether our action will change the system or not, that is immaterial. Our father of our nation, Mahatma Gandhi ji, who also belonged to our profession, he has said, whatever the changes that you want to make in the world, first make changes within yourself. That is very difficult. So therefore, dear friends, just apply these three methods: good thought, good speech, and good action. Unless and until we build up the character, morality, integrity, the judgments or the offences, whatever it is prescribed in the IPC or the new act, will become meaningless. However the imposition of the punishment, everybody knows for a murder there is a death sentence, for a rape this is the punishment, everybody knows, but the offense is not stopped. The reason is we are failing in our duty by giving the fundamental lesson to the people. What is the fundamental lesson? That is realizing oneself. How do you realize oneself? You teach them morality. You give some credit in the school, one who speaks truth, one who follows punctuality, discipline. Don't go just by marks or what are the exams. What do they service they are doing to their parents, to their family, to their friends? Everything has to be taken into account. Our Dr. B.R. Ambedkar and other our forefathers, the founding fathers of the constitution, they have said, we have seen the constitutions across the countries and we have taken the suitable provisions to accommodate, to suit the Indian people. So the best constitution may turn out to be worst if it is in the worst hands. But bad constitution may turn out to be good if it is governed by the good people. So what is the emphasis here is, it is not on the provisions of the constitution, but on the personality of a person. So therefore, dear friends, if we are good, we become a good student, good citizen of this country, good advocate, good son or daughter for our parents. So goodness should not come from outside, it should come from within. So the answer to these offenses and everything, despite the judgment, despite the statutes, despite everything, why it is not stopped is character is not there. If wealth is lost, nothing is lost. If health is lost, something is lost. But if character is lost, everything is lost. So therefore, character must be built up everywhere. That is the reason professional ethics is not only the subject for law colleges, but also the subject for our advocate on record examination. This is my humble view for your kind consideration, dear friends. Now moving on to this Vishaka case, the paragraph number 2, the immediate cause for filing of this writ petition, why this writ petition was filed. The immediate cause for filing of this writ petition directly under Article 32 before the highest court of the land is an incident of alleged brutal gang rape of a social worker in a village of Rajasthan. That incident is the subject matter of a separate criminal action and no further mention of it by us is necessary. The incident reveals that hazards to which a working woman may be exposed and the depravity to which sexual harassment can degenerate, and the urgency for safeguards by an alternative mechanism in the absence of legislative measures, the need is to find an effective alternative mechanism to fulfill this felt and urgent social need. Paragraph number 3 of the judgment. See, paragraph number 2, they have said it was a brutal gang rape. She was a worker, a social worker in a village in the state of Rajasthan. She was brutally raped, and the criminal case is pending. But the writ petition is entertained only to fill the vacuum. There is no law governing a women at workplace. How to prevent the sexual harassment at workplace? The court cannot shy away the responsibilities by saying there is no law, therefore we will not enforce the law. Where is the law for enforcement? But the Honorable Supreme Court has held under Article 32, it gives us the ample power to issue any directions, writs in the nature of habeas corpus, everything. Therefore, by invoking Article 32, they have come out with guidelines to protect women from sexual harassment at workplace. Para number 3 of the judgment. Each such incident results in violation of which fundamental rights? It's a violation of the fundamental rights of gender equality and the right to life and liberty. It is a clear violation of the rights under Article 14, 15 and 21 of the Constitution. One of the logical consequences of such an incident is also violation of the victim's fundamental right under Article 19, Clause 1, Clause G. To practice any profession or to carry out any occupation, trade or business, such violations therefore attract remedy under Article 32 for the enforcement of these fundamental rights of women. This class action under 32 of the Constitution is for this reason a writ of mandamus in such a situation, if it is to be effective, needs to be accompanied by directions for prevention, as the violation of fundamental rights of this kind is a recurring phenomenon. It is stated in the year 1997, got reported, but it is going on. Recurring phenomenon. So, the fundamental right to carry on any occupation, trade or profession depends on the availability of safe working environment. Right to life means a right to life with dignity. The primary responsibility for ensuring such safety and dignity through suitable legislation and the creation of a mechanism for the enforcement is of the legislature and the executive. When, however, instances of sexual harassment resulting in violation of fundamental rights of women workers under 14, 19 and 21 are brought before us for redress under Article 32, an effective redressal requires that some guidelines should be laid down for the protection of these rights to fill the legislative vacuum. So, under this, the Honorable Supreme Court has laid down guidelines. So, what is the power? They derive the power from where? What is the source of their information? What is the source of their power to issue the guidelines? It is stated in paragraph number 16 of the judgment. In view of the above and the absence of enacted law to provide for the effective enforcement of the basic human right of gender equality and guarantee against sexual harassment and abuse, more particularly against sexual harassment at workplace, we lay down the guidelines and norms specified hereinafter for due observance at all workplaces or other institutions until legislation is enacted for the purpose. This is done in exercise of the power available under Article 32 of the Constitution for enforcement of the fundamental rights, and it is further emphasized that this would be treated as a law declared by this court under Article 141 of the Constitution, the guidelines and norms prescribed herein. So, the Honorable Supreme Court derived their powers under Article 32 of the Constitution of India to frame guidelines. Generally, it is a legislation, there should be a legislation. When there is an absence of legislation, it is called judicial activism. There are grey areas where the Honorable Supreme Court could not find any law on this. Therefore, the Supreme Court, being the protector, being the custodian of the fundamental rights, they cannot shy away from their responsibilities. Therefore, until the suitable legislation is enacted by the parliament, this law or the judgment, whatever the guidelines that I have laid down, would be operating as a law, judge made law, and it is binding on law of the land under Article 141 of the Constitution of India. So they have described what are the responsibilities of the employer. If there is a sexual harassment, what should be the protection? Then there should be a disciplinary committee. Everything they have mentioned in the Vishaka guidelines. It is called Vishaka guidelines. Now, Vishaka guidelines has taken the act. It has enacted in the year 2013 after Nirbhaya incident, if I am not wrong. Here, one of the objects and reasons given here is the Supreme Court of India, in the case of Vishaka versus State of Rajasthan, 1997, Volume 7, SEC, page 323, also reaffirmed that sexual harassment at workplace is a form of discrimination against women and recognized that it violates the constitutional right to equality and provided guidelines to address this issue pending the enactment of a suitable legislation. It is thus proposed to enact a comprehensive legislation to provide for safe, secure and enabling environment to every woman, irrespective of her age or employment status, other than domestic worker working at home. So domestic worker, this act will not be applicable. Free from all forms of sexual harassment by fixing the responsibility on the employer as well as the district magistrate or additional district magistrate or the collector or deputy collector of every district in the state as a district officer, and laying down statutory redressal mechanism. So, when there is no law at all, when the Vishaka judgment came, no law governing or protecting the women at workplace. But our Honorable Supreme Court, as a custodian of the Constitution, have laid down the guidelines. And ultimately, it has taken the form of legislation as a statute in the year 2013. That is, the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. But this act did not stop the offences. Still it is going on, recurring phenomenon. This only when we change the mindset. Now, let me move on to yet another gender equality judgment, that is where the transgender wanted to be recognized as a third gender. So, the name of the case is National Legal Services Authority. National Legal Services Authority versus Union of India and others. This case has come up before the Honorable Justices, Honorable Justice K.S. Radhakrishnan and Honorable Justice A.K. Sikri. It got reported in AIR 2014 Supreme Court, page number 1863. I repeat, AIR 2014 Supreme Court, page number 1863. So what are they seeking? Here, National Legal Services Authority has approached the Honorable Supreme Court. Let me read a few paragraphs, dear friends. Seldom our society realizes, they start with a pain, note of pain. Seldom our society realizes or cares to realize the trauma, agony and pain which the members of transgender community undergo, nor appreciates the innate feelings of the members of the transgender community, especially of those whose mind and body disown their biological sex. Our society often ridicules and abuses the transgender community, and in public places like railway station, bus stands, schools, workplaces, malls, theaters, hospitals. They are sidelined and treated as untouchables, forgetting the fact that the moral failure lies in the society's unwillingness to contain or embrace different gender identities and expressions, a mindset which we have to change. Dear friends, again, the Honorable Supreme Court has also said, when we are ignoring or ridiculing the transgender, what is the necessary is to change our mindset. Para number 2, we are in this case concerned with the grievances of the members of the transgender community who seek a legal declaration of their gender identity than the one assigned to them, male or female, at the time of birth. And their prayer is that non-recognition of their gender identity violates Article 14 and 21 of the Constitution of India. Hijida, Unak, who also fall in that group, claim legal status as a third gender with all legal and constitutional protections. Para number 3, the National Legal Services Authority, constituted under the Legal Services Authority Act 1997, to provide free legal services to the weaker and other marginalized sections of the society, has come forward to advocate their cause by filing a writ petition number 400 of 2012, writ petition number. So now, in this case, the Honorable Supreme Court has come out with several guidelines. We therefore declare that the transgender should be treated as a third gender for the purpose of safeguarding their rights guaranteed under Part 3 of the Constitution, and the law is made by the Parliament and the state legislature. Transgender persons' right to decide their self-identified gender is also upheld, and the center and the state government are directed to grant legal recognition of their gender identity, such as male, female, or as third gender. We direct the center and the state government to take steps to treat them as socially and educationally backward classes of citizens and extend all kinds of reservations in cases of admissions in educational institutions and for public employment. Center and state government should seriously address the problems such as fear, shame, gender dysphoria, social pressure, depression, suicidal tendencies, social stigma, etc. Center and state governments should also take steps for framing various social welfare schemes for their betterment. So we are informed an expert committee has already been constituted to make an in-depth study of the problems faced by the transgender community and suggest measures that can be taken by the government to ameliorate their problems and to submit its report with recommendations within 3 months of its constitution. Let the recommendations be examined based on the legal declaration made in the judgment and implemented within 6 months. So after this judgment, dear friends, the Parliament has come out with a statute. The name of the statute is the Transgender Protection of Rights Act 2019. Judgment got reported in 2014, the Transgender Protection of Rights Act 2019. So now we have seen different avatars of PIL, and last but not the least, let us go to the next avatar of PIL, protecting the environment, for which I will cite one case. Vellore Citizens Welfare Forum versus Union of India and others. It got reported in 1996 Volume 5 Supreme Court Cases 647. 1996 Volume 5 Supreme Court Cases 647. The matter came up before the Honorable Justices, Honorable Justice Kuldeep Singh, Honorable Justice Faizan Uddin, and Honorable Justice K. Venkataswamy. In this case, dear friends, Vellore Citizen Welfare Forum has filed a petition before the Honorable Supreme Court as a PIL. For what purpose? See, it goes like this. Let me read few lines of this. This petition, this is how it starts. This petition, public interest, under Article 32 of the Constitution of India, has been filed by Vellore Citizens Welfare Forum and is directed against the pollution which is being caused by enormous discharge of untreated effluent by the tanneries. When there is a tannery, when there is the water, untreated water is polluting the river also, polluting the groundwater also. Therefore, many hectares of land, their cultivation land has become sterile. There no cultivation takes place at all. Therefore, this petition was filed. Not only that, it pollutes the groundwater, it pollutes the river. So, where is the question of sustainable development? You damage everything. So, therefore, the Honorable Supreme Court has said that protection of environment is guaranteed under right to life and personal liberty under Article 21. Right to live in a cleanly environment. And then other provisions of the Constitution provides for the clean environment. Like, let me take you to the relevant provisions of the Constitution. Like 48 capital A, protection and improvement of environment and safeguarding of forest and wildlife. And 51AG, that is one of the fundamental duties to protect and improve the natural environment, including forest, lake, rivers, wildlife, and to have compassion for living creatures. So these are the constitution provisions. Not only that, apart from that, statutes are also there, like Water Prevention and Control of Pollution Act, Water Act, Air Prevention and Control Pollution Act. So several acts are there. So Constitution provides for safe environment, clean environment, but still how these tanneries can pollute the groundwater. Therefore, it is a violation of their fundamental rights. So the Honorable Supreme Court has come out by saying polluter pay principle. Polluter pay principle means whatever, to what extent they have polluted, they need to compensate the people, those who are the victims, therefore to restore the damaged portions. So polluter pay principle is evolved. And when we talk about this environmental issue, I will be failing in my duty if I do not take renowned lawyer M.C. Mehta. His contribution has to be recognized. It's already recognized, and he has received so many awards. And we must remember here, he has filed many cases with respect to the environmental issues, wherein polluter pay principle, precautionary measures, then doctrine of sustainable development, doctrine of absolute liability has been evolved, and it has become part of the law of environmental. Those doctrines have become law of the environmental law. So therefore, we are concluding now, dear friends. So now, let me sum up with respect to the different avatars of PIL. We started by saying that Article 32 Clause 1 of the Constitution guarantees that right to move the Supreme Court by appropriate proceedings for the enforcement of the right conferred under this part is guaranteed. So what is the appropriate proceedings? Appropriate proceedings means by way of filing a writ petitions as prescribed in the Supreme Court rules. But when a person who is unable to engage a lawyer, who has no means, neglected children, bonded laborers, and no means at all, illiterate, so those people cannot approach the Supreme Court. Therefore, public spirited person with bona fide, who has no personal interest, can address a letter to the letter to the Honorable Supreme Court that can be treated as a writ petition, because the Honorable Supreme Court has said that you cannot expect the public spirited person to spend money from their own pocket. Therefore, we treat it as a genuine letter, as a petition, and then we will provide remedy. The form is immaterial. The purpose is enforcement of fundamental rights, for which the one avatar of public interest is to protect the prisoner's rights. Yet another avatar to protect bonded laborers. Then prevention of sexual harassment at workplace. and then environmental issues, then protecting transgender, guaranteeing gender equality. So it has taken different avatars, and there are yet another many avatars are there. Time is very very limited, and you cannot write for 20 marks or 25 marks all these judgments. So all these judgments must be remembered, and you must remember the honorable judges, their quotations, and we have to learn only one thing from here. Whenever you interpret either the constitution or any other statutes, you can always correlate with the preamble, with the fundamental rights, with the directive principles of state policy. Therefore, to have a holistic view about the provisions of the constitution. So with this, I am concluding this session for today, and we would be dealing in the next session about misuse of public interest litigations. How the Honorable Supreme Court has evolved this PIL, but how it is being misused, therefore how they have come out with the guidelines to prevent the misuse. Because public interest litigation, after some time it has become, PIL has become publicity interest litigation, paisa interest litigation, and motivated personal vendetta. So how the Supreme Court has come out with guidelines to prevent this misuse, abuse of PIL, and we would also deal with how to draft public interest litigation petition under Article 32. Drafting is very important because drafting will act as a bridge between the victim and to the court. This is a vehicle. So therefore, we would deal with those topics in the coming sessions, dear friends. I am truly honored and privileged to stand before you, to share my thoughts, to share my little knowledge with all of you. Thank you so much for your patience hearing. Thank you. Thank you, sir.